Okay, so let's get into it. Let's look at the two mechanisms that, or the two vehicles, if you will, that R. Kelly can use to get himself in front of a judge so he can get his arguments heard. Now, the first one I mentioned is a 21301, and I've actually found it. And for some reason, I'm not sure what's going on with the this website here, but basically, it's giving me stuff that I don't want, right? So I did a search, and up top it has 2-1207. I haven't read that. I don't know what's about. But what we're actually looking for is 735 Illinois Civil Code and Procedure, or actually here's Illinois Compiled Statutes 2-1301. And as you can see, this baby is pretty lengthy here. I definitely don't want to put you to sleep by trying to read all of it. So I've read it. I've saved you the punishment of reading it all to you. I've read it, and what I've done is picked out, some of the parts that I thought were most important. Right. Again, before I get into this, I'm not a lawyer. I didn't go to law school. I'm not licensed to practice law, so this is basically being done under freedom of speech, and it's for education and mostly entertainment purposes only. All right, so don't go to court basing your arguments off of the stuff I'm presenting here to you today. You might get yourself in trouble. So anyway, basically the 21301 says judgments default confessions. The court shall determine the rights of the parties and grant to any party any affirmative relief to which the party may be entitled or on the pleadings of proof. Judgments will be in the form required by the nature of the case and by the recovery or relief awarded. Right? That's the first part of it. Then it goes on, it says that judgments by default may be entered for want of appearance or for failure to plead, but the court may, in either case, require proof of the allegations of the pleadings upon which relief is sought. So essentially, this sounds like the reason that Heather Williams won this default judgment, because R. Kelly never filed an appearance, and he never really made any pleadings, right? And he basically just didn't show up. He didn't file an appearance. He didn't show up. He didn't make any arguments. And Miss Heather Williams, or HW, if you will, she shows up. She makes her argument, and the judge is like, "Okay, I'm going to give you a judgment. Boom, let's move on." Right? So, Section E, or Part E, basically says the court may, in its discretion, before final order or judgment, set aside any default, and may, on motion filed within any 30 days after the entry thereof, set aside any final order or judgment upon any terms and conditions that shall be reasonable. Right? So essentially, where Part D gives her a right to a default judgment, Part E gives R. Kelly the right to vacate that default judgment. Right? So basically, within 30 days, I think he just has to make a reasonably good argument on why this judgment should be set aside. And from my understanding, what they'll do is that they'll vacate that judgment or set it aside, and they'll give him an opportunity to tell his side of the story, and then she'll have to retell her side of the story, and then they'll fight and go back and forth. And basically, the strongest litigator wins at that point. Right? So let's look at the second mechanism, which I spoke about, which is called the 21401. So the 735 Illinois Compiled Statutes 5 to 1401. Right. So again, this statute is, well, it's actually a civil code of procedure. It's pretty lengthy. I'm not going to read all this to you. I've spared you that, and I have summarized it. Right. So basically, the 21401 says that relief from final orders and judgment after 30 days from the entry thereof may be had upon petition as provided in this section. They're basically saying that if you find out that you have a judgment against you and that 30 days have passed, you can use this to get that judgment thrown out, right? And then it goes on to say the petition must be filed in the same proceeding in which the order or judgment was entered but is not a continuation thereof, right? So essentially what that is saying is that you generally want to go back to the same judge who entered that judgment, and you're going to file this petition to be heard by that judge, but you're not trying to continue that case. That case is pretty much over. Basically, what has to happen is that they're going to have a hearing on why that judgment from that case should be thrown out, and basically you're not continuing that case, but this petition here is essentially about the vacating the judgment from that case. So you're not continuing that case. You're basically having a hearing. And I guess the reason being, if you lose, that judgment is still going to stand. That case is over. That's done. Is it res judicata applies. But if you win, then the judgment is thrown out, and then the case is restarted again or opened back up. Okay, so basically it goes on to say the petition must be supported by affidavit or other appropriate showing as to of matters not of record. So basically you're filing an affidavit or you're going in with some additional proof that wasn't already on the record, right? Then it basically, if you scroll down, and the 214.1 says the petition must be filed not later than 2 years after the entry of the judgment, right? So there's two conditions. Either the judgment is after 30 days, but less than 2 years, right? That's what they're saying. Or the time during which the person seeking relief is under legal disability or duress, or the ground for relief is fraudulently concealed, right? So now this sentence, if you will, basically gives you an opportunity for special circumstances. It's saying that if you had a legal disability, you were under duress, or there was fraudulent concealment involved, then basically the 2 year time period, the 30 to 2 year time period, 30 days to 2 year time period doesn't apply. So essentially, if you meet one of these criterias, there is no time limit, right? So this is section C of the 214.01, right? So then if you scroll down, it also goes on to say nothing contained in this section affects any existing right to relief from a void order or judgment, or to employ any existing method to procure that relief. So section F is actually another little gem, because basically this is another way that you can have a special circumstances where the time limit doesn't apply, right? If a judgment or order is void, it can be attacked at any time, right? I mean, that's just kind of common knowledge from folks in the legal community. If a judgment is void, it can be attacked at any time in any court, right? So that's essentially it for this video. I'm going to go ahead and end it, and because it's going on too long, and then I'll come back with a third video that's going to talk about duress, legal disability, fraud, and void orders.